Welcome, everybody. We are going to wait a few minutes to let people come in the webinar. Still waiting 1 more minute and then we will start. Okay, I think we can start. So welcome and many thanks to participate to the Challenges of Intellectual Property for SMEs in the Robotics and AI Sector webinar. This webinar is the first webinar of a series of 2. And today we welcome Isabelle Dor from the CEA, who is coordinating the EARASHI project. This webinar is organized in a framework of the European project EARASHI, and Isabelle will present what EARASHI is. And then Thomas Chadenet from June Avocats firm will present and dive into the challenges of intellectual property in the robotics and AI sector. So Isabelle, if you want to share your screen, and I leave you the floor for the presentation of EARASHI.
Yeah, so
thank you very much.
Hello, everybody. So I think I will go. So I hope you can see my screen now. Is it okay?
Yes.
Okay. Yes. So yeah, so really in a few minutes. So EARASHI is a European project, and it's it's aiming at developing, supporting onboarded AI robotic application for a safe human-oriented industry. It's a more than 3 years project, and one of the specificities, it is a cascade funding of financial support to third-party project. That's the main objective of the project was really to support a startup and SMEs to uptake new technologies in the frame of to improve human well-being at work. So you have here the consortium, and you can see that it's divided all over Europe with very different profiles from RTOs, industrials, some cluster center of excellence like Minalogic. So, well, the 4 main pillars of EARASHI is to improve working condition, trust, and acceptance of collaborative embedded AI in the AI robotic system for really the manufacturing sector. And as I said, it was really to support SMEs and startups in the uptake of advanced digital and eco-responsible technologies, really focusing on AI, data, and robotics to help employees in their daily activities and improve their working conditions. And really the objective was really to improve the working conditions, not to replace people. And it was a very strong aspect of the project. And so as you can see, we support SMEs, so we are providing services. And one big specificity is the worker-centric approach that has been really developed and deployed together with the SMEs within the project, considering workforce well-being and health design thinking, methodology of production machine, worker acceptance, and ethics. So really the goal and the structures. So we had, as we said, we are supporting SMEs. So we did organize a certain number of open calls to distribute this European funding in a fair way. And the way we were, the call were organized around challenges and technical building blocks that were provided by some of the partners. And every project has to select one challenge they wanted to provide answers to, and using some technical building blocks. And at the end, when they were selected, they were getting expertise, tools, and coaching in terms of eco-design, sustainability, expertise monitoring by industrial partners, and also by the model research centers. Something which is very important, that the objective is really to reach the market. So they were having some very strong support in terms of market exploitation, innovation management, really to be able to reach the market, to strengthen their business plan. And this human centricity approach deployment. So it was regarding human centricity, acceptance, trustworthy of the technologies, but also of the ethics of the data, because as soon as you speak about AI, data, and robotics, you enter kind of new world. And just the last slide is just to illustrate the 10 selected projects that we've been following during these 3 years. And you can see that even they are all dealing with AI, data, robotic, and to support workers at work. We are targeting very different kind of application domain. Some others are more robotic on the cell floor. Some others are more regarding manufacturing control, for instance, in the wind turbines. Some others is more about how to digitalize process in the manufacturing system, also to provide really more what we consider as robotic in terms of, well, when it's some very constraining task, repetitive task, and you want to help the people. So that's all I wanted to say. If you want to have more information, I will just say, look out, disappeared, on our website where we have all the storytelling and all this description of the applications. And of course, as we are talking about SMEs and startups, AI, data, robotic, somehow pop up the issue of industrial properties. So now I'm very pleased to leave the floor to our second speaker.
Thank you very much, Isabelle, and welcome everyone. I will also share my screen in a moment. Down there. Here. I hope you can see it. There. So
yes, we can see it.
You can see it? All right.
Yes.
Perfect. So yeah, welcome everyone, and thank you for joining this webinar on intellectual property, which is a topic that I found myself really interesting. And I'm very happy to be here today with you, as I feel that it is one of the kind of the most important job as a lawyer, is to be able to explain a specific field of law and to expand knowledge. So hopefully this is what we will do today. So just a quick word about myself before we start talking about intellectual property. So I've been a law practitioner for almost 10 years now, both in intellectual property and in information technology law. I worked as a law firm, as a lawyer in law firm, and also as an in-house counsel. So I'm well aware of the challenges that professionals can face, and both from let's say from like an external point of view, but also from like an internal perspective. And so about June Avocats, as a law firm I'm working for, It's a law firm created by Betty's Fayes. It's dedicated to digital law, intellectual property, and advanced technologies. You will get our contact information at the end if you want to reach out. So, as was said, this webinar is part of a two-session webinar. So today we're going to focus on basically what is IP, and on January 9, it will be at the same time, 11:30. We will focus more on the exploitation of your innovation as a source of value creation for your business, and focus on like contractual aspect as well. So be sure to register for this second webinar because it will also be quite interesting. So now, before we really dive into what is IP, I had this first question for you, and I was wondering, I mean, before we start talking about that, what intellectual property may mean for you. Does it relate to anything in particular, to a specific field? Is it something you see either as a positive or as a negative? I don't know if you're able to actually talk and use your mic, but if you have some answer or some stuff, yeah, that you can put in the chat. It's a way to protect my creation. Yeah, indeed. Indeed, does anyone have other thoughts on this? Okay, maybe not for now, but you know, I hope, and I'm sure that at the end of the webinar you have a clearer understanding of what IP could mean. And why I wanted to ask this question is because I know that from experience, for some CEOs, intellectual property can feel a little bit like an administrative burden, or an abstract legal field that is disconnected from the real world. So intellectual property might not be the first thing you have on your mind when you're focused on developing new technologies. And I mean, fully understand this, because you can assume that IP is for larger companies, or that your technology is too niche to be copied. But in reality, intellectual property is one of the most powerful legal tools that you have to protect your innovation, to secure fundings, or to gain a competitive edge. And as we know, business growth depends on the ability to innovate. But if your innovation is not correctly protected, you risk either to lose your market, or to leave the door open to your competitor. So that's why IP is important. It's a way to differentiate yourself from your competitor. Therefore, today I'm going to try to show you that IP is essentially an asset and how to use it strategically. And I won't get too deep into legal specificities. So what the webinar will not be, it will not be a legal lecture. So I promise I won't cite any article, any code, or anything of that sort. And you know, for a lawyer, it's a challenge, but we won't talk about that. It's not going to be either an opposition of artificial intelligence versus intellectual property, because it's a really trendy topic for now, and there are a lot of open questions about that, but also a number of great articles on this issue online. And finally, it's not going to be a lecture about the AI Act, because I know that with EARASHI, you already had a webinar on that topic. So we'll provide you with different information today. So what can you expect from this webinar? As I told you, to get a clear overview of what IP is, and also to get practical insights of how your IP can support your business. And be sure to stay until the end, because we will give you some kind of the key intellectual property questions that CEOs of SMEs should ask themselves in order to build a strong IP strategy. Therefore, today's itinerary, so the session will cover two major blocks. The first one is going to be an introduction to key IP rights and why they matter. And the second one is going to be a practical guide on how to protect your result and make strategic choices. Then, what is IP? So I've asked you the question. Now it's my turn to take a stand on it. Without getting too legally on it, I would say that IP is a set of legal tools that give you the exclusive right to use or control certain result of your creativity and innovation. And here what is important is the fact that it's an exclusive right, but we'll come back to it later on. And what is already important to remember there is that each of these legal tools has its own rules regarding how you obtain protection, how long the protection lasts, which office grants it, and how much it costs. But while each of these rights may be different, they serve a common purpose. As I said, it's like to give you exclusivity and to give your company a way to prevent others from freely copying or exploiting your work without your permission. So the idea to remember is that basically IP, it's a toolkit. You don't have to use every tool, but you should know which one exists so you can choose the right ones depending on your business priorities, and so for you to make informed decision. So now that I've said that, we have a first glance about this toolkit, also about what are these intellectual property rights. And we come back to it in details later on during the webinar, but I just want to show you what it might be. So in order to do that, I kind of asked a question. So for example, you may ask yourself, how do I stop my competitor from copying my technology? Then question could be, the answer would be patenting. With patent, you protect a technical innovation. So basically, it's a product that provide a technical solution to a technical problem. So for example, if you're in, for SMEs in robotics, it would be kind of the core technical function of your robot. Then how do I keep something confidential without any limit of time? That would be a trade secret. Trade secret, you don't have to register for it, you don't have to pay for it, you just acquire it if you take certain steps. Then how do I own the line of code of my software, which is a very important issue for SMEs in the robotic and AI sector. And the answer would be copyright. So copyright, it protects the creative expression. So there it would be the source code, as long as it's original. It can also be your website content, your marketing videos, user manuals. All of this is protected by copyright. So if it's original, you own it, and you can prevent others from copying it. Then how do I ensure, I went too fast, how do I ensure clients always recognize and trust my products? So there was the answer, it's with trademark. Trademark, it's a sign that distinguish your goods and products from the one from your competitors. So it can be your brand identity, it can be a logo, a company name, anything, but we'll come back to it. And finally, how do I stop someone from making a product that looks just like mine? So it's about the look. There is design and model. So it protects only the visual appearance, the aesthetic of a product. So for a robot, it would be the look of a robot. So now that we've said all of this, so we've seen patents, trademark, design and models, trade secrets, copyrights, a set of different IP tools. And the key is to understand that these rights, they don't confront each other. They work together. So for example, for your robot, it can be protected by all 5 of these IP rights at the same time. So its new function, it could be protected by patent, its code by copyright, its look by design and model, its brand by trademark, and its internal parameter by trade secret. So that's why it's key to understand which are these rights, so you know which part of your robot is protected, and also to understand that they can work together. It's not one or the other. Now, I had another question for you. Is according to you, now that we have seen a little bit about what is IP, what could be the advantages of IP, or on the other hand, the disadvantages of IP? And once again, if you want to answer in the chat, I think you have the ability to do that. Otherwise, I have some answers of my own about that. Okay, so about advantages and disadvantages of IP. Administrative burden, but it also helps to protect and prevent anyone. Yeah, exactly. Wait, I'm lost. From copying my competition. Yeah, that's true. I mean, administrative burden, as I said at first, because sometimes you have to register for it, but it's always a trade-off. You have to sometimes to pay, to invest some time, some money, but at the end you will gain exclusivity. So it's always for something. Main disadvantage is that you have to disclose it. It's not secret anymore. Yeah, exactly. That's a good point. So disclosure, we'll come back to it later on. Disclosure, it's only affects for the patent law and also patent law. That's the main issue. But for example, if you choose trade secret, then you won't have to disclose it. But that's a good point. And it is when we will talk later on about the strategic choices that you have to make regarding IP. This is one of the issues that you have to keep in mind, disclosure. So yeah, that was a good point. And regarding patent, although they protect part of the system that is created, it is a detailed description of how something is made up. So it is practically an open question whether they protect you or open the way for copying. Yeah, that's interesting. With slight changes, the competitors can always avoid patenting blocks. Yeah, that's why it's that's a good point. It's always and it's a big cost. Yeah, you're right. It may be a big cost, but as I said, it's always a trade-off between what you pay for it and what you gain for it. Because with patent, you have a 20-year exclusivity on your invention. And as to answer to the first point, so as it would be like an open way for your competitors to copy. That's why it's very important to actually draft your patent registration in a very precise way in order to prevent this kind of issue. But yeah, but that's interesting because these are like kind of the main points. So disclosure, fear to be copied, and cost, sometimes time as well, because as we will see, IP rights, especially when you have to register for them, you don't acquire them. Sometimes you have to wait a long time. Sometimes you acquire them directly. So for SMEs that are in like kind of a fast developing environment, sometimes patent may not always be the right choice because you have to wait a long time in order for you to have your patents. Basically, when you granted a patent at the end, sometimes it can be too late and you don't use it anymore. So that's also something to keep in mind. Okay, yeah, that was interesting. Thank you for your feedback on that. So this was an issue about a patent. I also had an example in mind more about copyright. And for example, it's like if a startup hire a freelance developer to work on its software to be used in connection with its new industrial robot. So it's a freelance developer. Developer is getting paid by the company. Everything goes well. He works on the software. And at some point, he vanished. He's gone. So it's a blow for the startup. But then the startup still try to commercialize its robot with the embedded software. And when you try to commercialize it, it gets sued by the former developer for infringement. That's something that happened a lot, and we have been confronted with these kind of cases a lot. And basically what has happened there and how IP can be an advantage or a disadvantage. Here, IP could be seen as a disadvantage because the company has not correctly secured its rights at the beginning, because we'll come back to it later on, and also during the second webinar about that, on how to protect your IP through a contract. But when you're a freelance developer and you work on a software, basically the developer would be the author of the software, and so he would have a copyright. And if he had not actually licensed it to the company will not be able to exploit it. So here, for the company, IP could be seen as a disadvantage. But on the other hand, if the company had actually secured its rights beforehand, before exploiting the software embedded in the robot, the company would have had a competitive advantage, because it could have secured exclusivity on this software, so it would have been an advantage. So here is how you can see that depending on what you do, IP can be both an advantage and disadvantage, and usually it's about securely protecting your creation and your innovation, and that's what we are talking about right now. So when we have said that, my next question that said I'm gonna answer it right now, and we have covered that partially. So why IP matters, basically, because you could say, like, as we've seen, it's a burden, it's a cost, takes time, it's an open way to competitors to copy your invention, so that would be an issue. But why it matters, because it can also create a value. As you know, when you have a patent, a trademark, or other form of IP, it can be licensed, it can be sold, it can be used as a collateral for funding. So companies can generate additional revenues by licensing their patents or selling right to use their trademark. It can be a really important source of income. For example, if you have creating a new way to move your robotic arm, you could license it to other companies and creating a new revenue stream without giving up something, because it would just be a license. You would still own the patent, you would own the technology, but then other people using it would create revenues. And also another example, like for a SaaS provider, software as a service. The mainstream of revenue is basically licensing their IP, because software is protected under copyright laws. So when you want to provide your software to other people, to customers, basically you have to sign a license for them, and what they will pay you at the end would be an IP license. But once again, we'll dive deeper into this topic during the second webinar, but it was just to have that in mind, that it's a value creation. Then it also, of course, give you a competitive advantage, and that's because as it gives exclusivity, you would be the only one to control like a key innovation or a key logo, copyright, anything, key creation of your own. As you have exclusivity, of course, it gives you a competitive advantage compared to your competitors. There, it's also useful for a partnership. In that sense, partnership with other companies, they frequently require like a clear IP framework, to determine who owns what can you use, how royalties or license will be handled. And for example, we have seen, and that's part of the EARASHI project as well, companies that would on one hand do the software, other companies that would handle the hardware, and they would come together and do like cross IP licenses and like provide a new product together. And if at the beginning the IP rights are not clearly defined, then they cannot do this cross IP license, and then it would be kind of a lost opportunity. And that's why partnership is important. But for example, if you put your hand, if you consider yourself to be like the licensee, would you enter into a partnership with someone to exploit his new robotic arm if you're not sure that this person actually owns the right of this invention? Because then if you're not sure, you could put yourself at risk of being sued by the true inventor of the invention. And on the other hand, if you're the licensor and you are the one licensing your IP, you also want to be sure of what you will license. So the outlines of your IP must be clearly defined, so you know what you will license. There's not going to be any issues about that. They're also about investment, of course, because I mean, when you create a company, you can think about the exit strategy, but also before that about investment. And investors, they will examine IP position before deciding whether to invest. And we've been on both sides, on companies that were receiving money from investor and also from like the investor side. And basically what they want to know if you have a defensible asset, whether your technology can be easily copied, or whether you can block your competitor, or whether your competitors can block your freedom to operate. So that's why it's important to have that in mind, and also to have so I say like kind of a clear IP framework. It also increases the valuation of your company and demonstrates that you're kind of serious about your business and that you think about the long-term risk. So about that, internal IP audits maybe can be useful in that aspect to know what are your IP, how they are protected, what is your strategy. Once again, we'll talk more about this kind of strategic issue during the second webinar, but it's important to already have that in mind. And finally, why IP matters is because dispute, as I said, give you exclusivity, so it gives you the right, to sue for infringement anyone that you would use your IP without your authorization and obtain damages. So we've seen what kind of IP there is. We've seen the importance of IP, why it matters. So before going to kind of the second part of this webinar, so the kind of practical choice and practical guide and strategic choices you can make. Do you have any question about what have just been said? Okay, the chat. Okay, no, so far no more question. All right, okay. So we can go towards the practical guide. So I will start with patents, as I know it's very important for SMEs, especially in the robotic sector. The AI sector, we'll see that it's not that clear, but robotic sector, it's important. Here, what you can see is just an example of some kind of abstract of a patent from like the car company Stellantis. It's basically a new way of charging electric car by putting a charger on the road. So that's just an example. So as I said, and that is written on the slide, so a patent is designed to protect new and inventive technical solutions that solve technical problems. So we've seen that one issue is disclosure. I mean, one issue is not disclosure. It's about people knowing what your invention is when your patent is granted, because it's public. But before that, you have to think about whether your invention is actually patentable or not. And there is like one big issue. I mean, you may be aware of it, but I just want to stress it once again, because we see that mistake a lot, is that your invention must be new. And what does that mean for an invention to be new? It means that it must not have been publicly disclosed to the public anywhere in the world before your filing that with the patent office. And so this disclosure can be made by a third party. It can be made by the inventor itself and include published documents, a public demonstration, trade shows, anything that would make your invention public before your filing date. And for example, there, if you imagine an engineer that has developed a non-polluting fuel, and he's super proud of it, and he publishes his result in a scientific journal because he wants to show the world what he has created. And he files for a patent application the day after his scientific publication. Then his application for patent would be rejected because his invention is no longer considered new. So that's really something to keep in mind. And once again, about strategic choices and about IP law, you have to kind of anticipate a little bit because sometimes you will do certain action and it will be too late. You won't be able to actually protect your innovation the way you would have wanted to protect them. So that's kind of the goal of this webinar as well, is to tell you the main issue and so for you to have reflexes in that field. So it must be new. It must also have what's called an inventive step. So it means that it should not be obvious for an expert that the invention and the kind of a common example about that, it's a pencil eraser. When you have a pencil with a little eraser at the end, could be considered novel, but then the inventive step, it would likely fail this test because simply combining a pencil and an eraser, it would be kind of too obvious, so it would not work. And finally, for patent, your patent also need to have what's called industrial application. It means that it must have a practical use. It cannot just be a theoretical concept. It must actually be put in motion. So that's the main condition for patent. But the one really to remember is also the novelty issue. So do not disclose it beforehand. Then you can, if you meet the criteria, you can register it either nationally with a national office or either at a European level, so the European Patent Office, where you could gain a protection for the multiple countries in the EU. So that's something quite important. Surprise, because you may be interested about that, as was being said in the chat. It costs a lot. In France, for example, kind of the registration fees cost around 700 euros at the beginning. For European patents, more about 6,000. But then you also have fees that you have to pay annually, and also, as I said, if you want to draft your patent application in a really precise way, you might have to go and seek an IP lawyer to help you with that. Otherwise, you would have only kind of a very limited protection where you want to have the largest protection you would want. And then about time duration, but we also already seen that. It's 20 years from the filing date, and then after this 20 years, you lose your exclusivity. And so when we have said that, so you're going to tell me, so why should I register for patent? It costs a lot. It takes a long time. Oh, wait. So there is a comment in the chat. If inventor A has a granted patent for an invention that has not been publicly disclosed, is it possible for inventor B to obtain a patent for the exact same invention without knowing the inventor A, as it has never been disclosed, and like this having two patents for the exact same invention? Yeah, that's an interesting point. So maybe that's to come back to the novelty requirements. When you file for patents, you don't have to wait until your patent is actually granted in order to disclose it, because it can take up to 2 or 3 years or 4 years sometimes to actually have your patent granted. So for SMEs or for business owner, it would be too long. You need to have an invention created and then to have to wait 4 years until you disclose it. So sometimes you have authorization of disclosure to do so, and then it would be made public. And when you feel, so in that case of applicant A there. So he has a patent that is granted. So his patent is actually already public, even if it has not been disclosed, or even if the inventor has not used his invention in real life, that has not made it public. So the fact that he has a patent, so the patent registration is online, so everyone can see it. And then it means that for applicant B, he could not say that he is not aware of applicant A patent, because he would have the obligation to, it's called a prior art search report. So he has to look at the prior art, and prior art, it's what is in the, so it's prior art, so the state of the art is so the previous patent, the pending patent application as well. So applicant B would have to look at this state of the art, and within the state of the art, you would have applicant A patent. So I hope I answered the question. So basically, to answer the question, you could not have two patents for the same invention. But thank you. That was a good question. It gave us yeah. Thank you. You're welcome. But no, thank you. It gave us a way, to go a little bit deeper about what is a novelty, what is a prior art, and about what are kind of the steps you have to do. I mean, I didn't want to get too technical about that, and also I see that the time is running, but that was interesting. So maybe now, because we about trademark rapidly. So here you have an example as an OpenAI trademark. To show you the trademark, it's a sign capable of distinguishing the good of services from one company from the other company. And a trademark, why I put this one, say it could be either a group of words. So let's say it could be like only OpenAI. It could be a logo. So here, what you see on the left, and it can be also a combination of a logo and a group of words at the same time. So that's why I thought this example was important. So, so that's what a trademark is. You also have other condition, more or less the same condition as for patent, as would not be the state of the art there, but we said that when you register for a trademark, this trademark has to be available. Available, it means that you should not have like an identical or a similar trademark or similar sign that already exists. And just something I want to point out for trademark is that you have protection, you have a monopoly on a sign, but only for what's called a class protection. So only for a certain product or certain services. For example, OpenAI, there I saw that they're registering like into a software group of products. So it means, I mean, kind of that if tomorrow you want to open, I don't know, a bakery that's called OpenAI, you may be able to do that because OpenAI, this sign is only protected for like kind of the software area and not for the bakery area. So that's something to keep in mind, is the class protection. And also one important issue about a trademark is time duration. So you have a monopoly that lasts for 10 years, but then you can renew it indefinitely. So it can last as long as your company exists. You also have a national trademark and European trademarks if you are interested about that. The cost, it's way cheaper than patent. In France, it's around 200 euros for a national trademark. And for the EU trademark, it's around 850. So that's cover the whole European Union. That's something interesting. Then with design and models. Here I put you what you can see on the screen. I found it interesting to show it to you. Is one of the first MacBook. So it's a design and model from Apple from 1989. So more than 35 years ago now. And as I said, and why I choose Apple is because design and model, it protects the looks of a product. And Apple, as you know, they have really kind of iconic products. And for example, for the iPhone or for the MacBook there, for the iPhone, the shape and the look of the iPhone is protected by a design and model. So it means that competitors cannot copycat this look, otherwise they would infringe on Apple rights. So that's why I found interesting there. You also have kind of the same condition as with patents. So design model must be new. So it means that there are no prior rights on the same patent. It must also have an individual character, but maybe I won't get too deep into that. The duration lasts 25 years. And similarly, with patent or design model, you can have like a national design model. You can also have a European one. And also it's kind of cheap. So 100 euros for nationally and 350 for European one. All right, so now we have seen the 3-1 where you have to register for them. So patent, design model, and trademark. And so you also have copyright. And copyright, what is interesting is you don't have to actually register for it. You don't have to go in front of an office and to prove that you have met the condition to be protected. Your work will be protected as long as it's called original. Original, it doesn't mean that it's not a novelty requirement. It's not the same thing. It just means that you have to have some sort of, it means that your work reflects the personality of the creative choices of its author. It means that for a certain work, only this particular human being could have created it with his creative process. If you take someone else next to you, if confronted to the same situation, he could not have done the same. So basically, that's the idea behind copyright. It's also interesting, so because you don't have to register, you don't have to pay for anything. So time duration, it's the whole life of the author plus 70 years. So it's quite interesting. And in your sector, copyright actually protects software. So when we've seen that with a patent, it can cost a lot, take a long time. If you just want to protect the software you've created, then you can rely on copyright and protect especially the source code. I mean, there are very interesting issues with that, especially with artificial intelligence. But I'm sure you've all read about that already, about who can own the copyright. So whether it would be like a natural person or a legal person. So basically, can OpenAI be considered the author of the outputs? I mean, so far, no, because with like most traditionally and all around the globe, author of copyright can only be natural person. But we'll see. I mean, it's still an open question for AI. We will see if it evolves in the year to come. And then lastly, about trade secret. Well, I don't have a picture there, but trade secret, it's mainly about confidential information. So you also have to have certain conditions. So as it's a trade secret, your secret must not be known. It must have commercial value. And you must have taken what's called reasonable steps to protect it. Basically, to sign a non-disclosure agreement, to be sure that not everyone in your firm has access to this trade secret. So to be really cautious with it. And also, what's interesting is you don't have to register for it. You don't have to pay. So that was kind of the practical guide about, I wanted to go a little bit deeper about what is IP and what are the conditions. And we've seen that for example, for patents, there are some specific conditions to keep in mind. Now, I just wanted with you to take a kind of a step back about what we have said, because you as CEOs or as engineers or are people that will actually create, you may have strategic choices to make. And these strategic choices can depend on your technology. I mean, is your technology, for example, patentable, or do you want to protect it under copyright on your resources as well? Because we've seen that the costs are not the same at all. And on your business objectives as well. For example, what do you want to do with your technology? Do you want to license it? Do you want to keep it secret? Do you want to make it evolve in a few years? And all of these are questions you must have in mind when dealing with intellectual property and dealing with your own creation. And so here you have three issues, and I just wanted to say that sometimes you can, as I said before, IP rights can work together, but sometimes you have to choose. I mean, you don't have to choose, but you could choose one or the other. For example, between patent or trade secret. One very known example about that is Coca-Cola. Coca-Cola, they have never patented the recipe for their drink. If they had done so, I think it was the beginning of the 19th century, of the 20th century or the end of the 19th century, they would have been protected only for 20 years, and they would have fallen into the public domain for a long time. But they relied on trade secret, and their recipe is still a secret today, and so they can still have this competitive advantage that they would have lost if they had chosen patents. But on the other hand, if you have, for example, a technology that would be kind of easily reverse engineered, then a patent might be worth the investment. Otherwise, your competitor will quite easily reverse engineer and kind of do the same. So once again, we see that with different issue, you can have make different choices. There is also an issue about disclosure, but we already talked about that, about cost as well. And finally, I wanted, well, yes, we have a couple of minutes left. And I will leave you if you have some time, if you have some questions about software, because software, it's a very, I mean, on my end, a very interesting topic, as when we talk about software and when we talk about algorithms are excluded from protection. When you take them in isolation, only algorithm, they are considered to be a series of mathematical operations, and as so, for IP law, it's considered to be only idea, and so it cannot be protected, as idea should be what's called like free to circulate, and so it cannot be protected under copyright law, and it cannot be protected under patent law. However, copyright law, it protects software. So if you have an algorithm that is incorporated into your source code of software that is original, then you would kind of indirectly be able to protect your algorithm by protecting the software. And same with patent law. So algorithm by itself cannot be patented, but if it's an algorithm that is included in like a computer invention, so if the algorithm is part of a larger technical invention, this larger technical invention would be protected, and then so the algorithm would be also indirectly protected. So that's very interesting. There are a lot of issues about that. We could talk about that for hours, but I see the time is running, so I will wrap this up. But of course, if you have questions about that, be sure to reach afterwards. And so finally, as I told you, I wanted just to give you kind of a few questions you have to keep in mind while dealing with IP protection. So the first one would be, it's really basic question, but it's kind of reflexes that you have to have. So first one, has my company or someone working there created anything? That's kind of the first idea, just to spot where IP could be within your company. Basically, it's about creation. It can be the marketing department. Have they created a logo that has worked very well that they use now? It's the R&D team that have created an invention that you use. Anything. Then, does this creation represent an asset? Because of course, I mean, you could create every day new creation, but they don't necessarily represent an asset if you don't use them. Or if I was talking about logos, for example, maybe you had a logo for 2024 and you don't use it anymore. You use a new one for 2025. So the 2024 logo will not be considered an asset. So that's also something to have in mind. Then, has my company taken any step to protect this creation or keep it confidential? And you see here, we're getting a little bit more deeper on what we have said. So taking any steps. So can everyone in my firm have access to this creation, or if it's confidential, does only like certain type of people have access and not the other ones in order to keep it confidential? So that's some of the questions. Then it's kind of related, but how does my company plan to use this creation? Because if you plan to use it for only a couple of years, maybe the patent application will not be the right call there to protect your creation as a patent application. As we've seen, it lasts for a long time. So if you want something, a protection that is more immediate, maybe you could rely on copyright or trade secrets. So you see, by asking yourself these questions, then you can more or less see what IP right and so what sort of tool may be needed. And finally, how much money and how much time does my company intend to allocate for the protection of this creation? Because that's always an issue, especially for startup and for SMEs. I mean, we know that basically money is not always allocated to legal matters, but as we've seen, by investing sometimes money, then you would gain, I mean, on IP protection, then you would gain exclusivity and have a competitive edge and be able to license it afterwards. So basically it would be kind of an investment. So yeah, here are the 5 questions. I see that we have a couple of minutes left. If you have any question, just, I wanted to remind you, so stay tuned for the second webinar on January 9th. We'll get a bit deeper about the strategies that you can put in place, both internally and externally, about the contracts. So it will be also very interesting. And finally, thank you for joining today. So you have our contact information there. So if you want the slides, for example, be sure to reach, or if you have any question. And thank you, Laura. She had just providing the link for the second webinar. So if you have any question right now, we'll be happy to answer them. And otherwise, thank you, and you can reach us by email. Great, thank you. Wait, I see.
Yes, there is a question.
There was a question. Hello, Maria. If I create something new, but I'm not sure about using it, is it necessary to protect with a patent, for instance, or maybe a trademark? Or maybe trademark my brand, even if I'm not sure about exploiting it for the time being? Well, it's interesting. It kind of relates to the questions, the 5 questions I've just wrote is like, how do you intend to use it? Because if, for example, you have a trademark, or it's not a trademark yet, but a sign that you don't use and you don't intend to use it, then, I mean, you don't have, to bother with a trademark registration. But if you feel it's a good sign, you don't want to use it for now, but you want to use it later, then for trademark, you could directly register it, because as we've seen, trademark registration, it can last indefinitely, and you can always renew it. And so you would be sure to protect this trademark. But at the same time, for trademark, there are other issues that I haven't talked about, but when you register, if you don't want to lose your right on the trademark, you have to use it. So if you register, you have your trademark, and you really don't use it at all for a certain period of time, then you will lose your protection on it. You're welcome. All right, so I think I don't see any more questions nor any hands that are raised. So, well, thank you very much for your time today. Yeah, I hope it was helpful that now you have a clearer view about IP and about how to protect your asset. And yeah, we'll be really happy to see you in January for the second part of this webinar.
Thank you very much, Thomas.
Yep, thank you very much indeed. And
okay,
see you
so we're
next
going
year.
to close the webinar. Many thanks. Bye-bye.
Bye-bye. Thank you.
Bye.
Bye-bye.